Hi, my name is attorney Amanda Schaefer. Today, we are going to talk about how to win in immigration court, and specifically some of my tips that I tell all my clients. I'm going to share with you all today. Before I begin, quick reminder, don't forget to like us, follow us on Facebook, YouTube, Instagram, wherever you are watching. And if you find this video to be helpful or know someone who may, hit that share and save button. All right, let's get down to it. So, I should also mention to stick around for the end of this video, or if you're watching on repeat, on replay, you can, I recommend that if you don't want to watch the whole thing, skip to the end, because I'm going to give you my insider tips for testifying. Now, the truth of the matter is that winning your case starts well before you step foot in immigration court. And that's the case for any court, to be honest. And that's why it's recommended highly that you contact an immigration lawyer if you're in immigration proceedings at the earliest possible time, even if you're just touching base to find out the cost so you could save up for it. The sooner you contact the lawyer, the sooner we can start preparing your case. When you come in last minute, it can be very difficult. And so I can't underestimate that point enough. Now, in immigration court, there are two types of hearings. There is a master hearing, and there's what's called an individual or a merits hearing. You're going to have at least one of each. If you're lucky and you have a minimum number of court cases, you'll have one master hearing and one individual. There's all sorts of reasons why you'll have multiple. Sometimes it could have to do with you. It may have nothing to do with you. But the main difference is for the master calendar hearing, it is very short. The longest part, I tell my clients, is waiting to be called. But you're in front of the judge for 5-10 minutes. You go through. So when you were placed in removal proceedings, you got a document called a notice to appear in immigration court. And those are your pleadings. They tell you why the U.S. government is trying to deport you from the country. So you go through the pleadings. Usually it says like you're not a citizen or national of the U.S. You're a citizen or national of wherever you're from. And then it will say you entered the country on this date with this visa. You're authorized to stay for this long, or you enter the country illegally or at an unknown date, unknown time, whatever information they have about your entry. And then there could be more pleadings than this or more factual allegations than this, but the typical ones, then they'll say, okay, you overstayed your visa, you entered unlawfully, you committed fraud. This is the last factual allegation. And then we go to the removability provisions. So that's the area of law the government is citing to say, okay, you violated this law, so this is the law we can use to deport you. And then the judge will ask, do you want to designate a country for removal? That means if you lose the case, do you want to tell them which country they can send you back to? If you're applying for asylum or any case where you're dealing with a hardship and saying you can't return to your country, you're going to respectfully decline. They'll still designate your country of citizenship or nationality. If you have multiple, sometimes they'll designate multiple. Now, there are two types of asylum that you can apply for. One is affirmative asylum, and one is defensive asylum. Main difference is that you apply for affirmative asylum before you get placed into removal proceedings. So even if you got caught at the border crossing and you were going to apply anyway, and you applied, if they put you in removal proceedings already, it's considered a defensive application. So the other difference is when you apply affirmatively, you're going to have an interview with the asylum office. If they don't approve your case, it will be referred to the immigration court. Whereas with the defensive asylum application, you're not going to have an asylum interview with the asylum office. You're just going to have your individual hearing. And now let's get to the asylum filing. So you might be in removal proceedings already, like I said, because you got put in there for whatever reason. Could have been a criminal issue. It could have been your um, green card application was denied. Who knows? Whatever reason you're in it, you're in removal proceedings. If you're not, and you've applied for asylum on your own, first and foremost, I do, again, highly recommend that you use an attorney from the get-go, even though an attorney can help you fix your case later on if it's not approved right away. Um, it's not like your initial application just disappears because you didn't have an attorney, or that they're not gonna compare anything. They're gonna if you're gonna have to give a more updated statement, for example. They're gonna ask you why certain details were left out. A lot of times, it's actually completely reasonable and understandable that you didn't know you needed to include certain evidence. That's fine, but it's always easier when you start it from the beginning correctly. So when you do hire an attorney, and now I'm assuming at this point you went to your asylum interview if you had one, they didn't approve you, very low percentage of cases get approved, and now you have to go to a master hearing and you need to find an attorney. And it's very important to have an attorney representing you in immigration court. If you don't believe me, I should have pulled the statistics. The statistics show that you're at a significant disadvantage if you don't use an attorney. So the first thing your attorney should do is review everything, see what was filed. Hopefully you have a copy. We can get your file if you don't. Um, but in all likelihood, especially if you didn't have an attorney help you file it the first time around, you're going to need to file a new, it's called the Form I-589. It's the application for asylum, withholding of removal, and withholding under the Convention Against Torture, all three at once. If your attorney reviews it and says, you know what, you filled this out pretty well, we don't have to do it right away. Let's wait. We'll update it before your individual hearing, because you're probably going to have to do that anyway. You always have to tell the court if there are any updates to your application. If you change jobs, if you get married, if you get divorced, if you have children, if you move, any change that there possibly is, you have to tell them in the application. So what I always do when a new client comes in, depending on how far away their individual is, if it's really far away, I'll review the application. If it's just, you know, we can't even, it doesn't even make sense, then I'll immediately do a new application. But I still will update it. I think right now the practice book says 15 days before your individual hearing, you have to submit any updated applications and evidence. And although some judges will say 30 days, but either way, within a few months before, you're going to want to update it, whether or not you submitted a new one. The next thing and this is really the most important thing, is your detailed statement about why you're applying for asylum, why the US government should not send you back to your country. This is going to be the basis of your testimony in court. When I write the questions out for my clients to practice with, I use their statement. So if you don't have a detailed statement and you don't address all the issues that you need to address, you're going to have a hard time winning your case. This is also the most important because a lot of times with asylum cases, you don't have a lot of physical evidence because you're fleeing your country, because you're being persecuted. So it's okay if you're missing some things, that's allowed, but you have to actually explain in your statement, as part of your statement, not just why you're applying for asylum, but if you don't have evidence, if you don't have witnesses that are writing affidavits, well, why couldn't you get that? And there are perfectly good reasons for it, but it has to be explained. So you need to explain in the statement why you're applying for asylum, why you're afraid to return home. Do a detail, and I mean who, what, why, where, when, how, as much details as possible about any past persecution you suffered, so any harm that you suffered back before you came to the United States. If you have returned to your country since coming to the US, then you need to explain how you're able to return and, be safe, but now you can't return and be safe. And again, I've won countless cases of asylum where people have returned to their country. That doesn't mean your case is dead. Sometimes whatever whatever the reason was for you fleeing, that reason didn't exist when you last time, when you were in the US the first time or in another country. And then you go back to your country, it happens, so now you flee. That's fine. We just have to explain it. Sometimes it gets worse, whatever the case may be. We also have to address internal relocation. So, did you try to live somewhere else in your country before you came to the US? If yes, how long did you stay there? Were you safe? If you were safe, why didn't you stay? If you didn't try to internally relocate, now you have to explain why there was no point in you trying. Again, I've had plenty of cases where I've had uh, where clients have done both, where they've either attempted to relocate internally or didn't. They'll both get approved. It's just all about the explanation. If you have any criminal history, this is very important too. You need to explain what happened, even if your charges were dropped. And then you want to include any updates since you left your country. Is there any change in country conditions? So is there a new government in power? And this government, whether it's a political claim or not, the form of government can matter. It could be you could be on the LGBTQ community, and this new government says it's illegal to be gay, or the old government did, but the new government passed legislation now that says it's no longer illegal. So now we have to prove that if you're still saying it's not safe, we have to show that it's still not safe despite a change in law. And are the people that you're running from, or the person or persons, are they still looking for you? And how do you know? So this all needs to go in your statement. Just like your application, you should be submitting an updated statement in all likelihood, with some exceptions, those exceptions being certain people who are put on like the fast track. I believe right now it's people crossing the border illegally. In all likelihood, you will have years between your master and your individual hearing. And this is really hard for asylum cases. I've said this before. I've talked about my cases, because country conditions can change. You can have a new government come into power, and that can kill a claim. And that also may not even affect the claim. It all depends on the situation. But it's very important that these things are addressed, because if there is any change, like I've won cases where the president changed, but the next president was from like a different political party, but really it was the same political party. Like they supported each other. So that's our burden to show that's the case. And if you're thinking already that this is a lot and this is confusing, well, that is why I recommend getting your lawyer as soon as possible. Next, let's talk about evidence of persecution. And this is evidence you want to get as much as possible. And as I said earlier, if you cannot get the evidence, you're going to explain what efforts you used to get the evidence and why you don't have it. And yes, you can call someone back home and say, hey, can you go to that hospital I was in and pick up the medical record? That's perfectly fine. You don't make it up. Don't, fake evidence, but you may have fled your country without certain things. If you have someone back there who's able to get you that evidence, great. That's why you want, again, to meet with the lawyer early, so you know what you need to give people time to get that stuff. We're also going to include country condition evidence. You're welcome to submit your own country condition evidence. I would, again, run it by your lawyer regardless. It does have everything has to be in English. If it's not, a certified translation must accompany it. That's one of the more difficult things about using articles from abroad when they're not in English. But you don't have to worry too much about the country condition evidence when you have an attorney, because I will be looking for it. There's primary sources that we use, like the Department of State country condition reports, Amnesty International, Human Rights Watch, the stuff that we know the judge is going to give a lot of weight to. If that evidence or those sources that I just mentioned, if they don't match what your claim is, and they don't always, because of the way that a lot of this information is obtained. Governments like to hide things that they do. So when that happens, that's when we start to look for additional sources outside of that. Easiest case, the country condition report, like from the Department of State, matches. I technically don't even have to submit it. The judge can take judicial notice. But again, it all depends. If there's only like a sentence about it, about your situation in the country condition report, I'm going to look for more evidence. You want it to be, you don't want there to be any question that uh, you about what's going on in your country. And don't assume the judge or the government attorney knows, because there's a lot of countries out there, and as far as I know, the way they assign cases is not based on country or issue, so you really do have to educate them. Now, before your individual hearing, before you want to, as I said, update your application, your statement, your country condition evidence. You want to get if you are going to have witnesses testify, and I can't speak for every immigration court across the country. I could tell you in New York, New Jersey, they're not big fan, even though there's virtual court, they're not big fans of virtual testimony for experts. You can, or not even experts, witnesses, sorry, excuse me. Experts, actually, they're okay with pretty much. But with witnesses, they usually, the witnesses should be in the U.S., even if they're going to testify virtually, even if your entire case is virtual. I haven't actually really tried to have someone call in from another country. I don't know if the system will let them in, but because of the time changes, it gets confusing. But it's really not necessary. They can write a letter, and that's what most people do. They just write an affidavit. But if you have someone that lives nearby, willing to testify, knows firsthand what happened, then great. And you want to file the updated application and evidence within the time limit. Like I said, that's right now. The practice manual says 15 days, but you have to check with your attorney, because if the judge told your attorney 30 days or even 60 days at the master hearing, like that's your deadline for evidence submission, then that's your deadline and you have to get it submitted then. So you should mark your individual hearing date in your calendar, and then a few months before, check in with my lawyer. Okay, now before the individual hearing as well, we want to practice. This is, look, the more prepared you are, the more likely that you're going to win. I always tell people I win court cases over even over other people, even when the facts aren't the best, because I'm better prepared. And I really believe that's true for some cases, and I believe that you can never be like a Boy Scout. You can never be too prepared. I think that's their motto. I think it's always be prepared. You know what I mean. Basically, you need to practice. The key is, like I said, if you did write your statement properly, your practice should primarily, at least, consist of reviewing that statement, making sure you know every detail on there. I always tell my clients, if you forget something, it's okay. You're not expected to remember every little thing, especially because these asylum cases deal with a lot of traumatic events that have happened, which can affect your memory, and that's perfectly fine. But you want to try to remember everything, because you're going to be nervous, so you want to you want to practice more than you think you need to. I highly recommend doing a practice session with your attorney. I do with every single one of my clients before their individual hearing. Either myself or Aaron will do it. Like I said, I tend to base the questions off of the testimony, the affidavit or statement that was written. And Um, client comes in, we block off a few hours. I ask I ask them the questions, they respond, and I kind of coach them through it, or I'll say, you said too much, or you don't have to answer that much, or that's not the answer, and then I'll star it. You need to practice it. Um, and I'll tell them, practice at home, practice having someone ask you the questions because we usually do the practice like a week or two before. Um, and also, while you're practicing, make sure there's no mistakes in your application or your statement, even if you've just refiled it. Mistakes happen, they're okay. It's always better if you or your attorney notice them and point it out to the judge before the trial starts, as opposed to you're testifying and the government attorney says, "Why does this say this?" And now you're saying that, and now you're flustered. And even though it's going to be okay, mistakes happen, but you don't want to feel flustered or anxious while you're testifying. Okay, now we're at trial day. Um, the day of, you want to dress respectful or nice. So I don't mean you have to wear a suit. I wear a suit to court. I had court today, hence the suit. But you don't want to wear ripped jeans or a crop top. You want to say fully cover yourself. Um, you you can wear dress pants. You can wear jeans if you want, but like I said, just look respectful. And I don't really care. It's the judges who care. Get there early, even if you're doing a virtual hearing. Um, I have clients come to my office to do virtual trials. If I tell you to come here at 2:00 for a 2:30 hearing, get here at 1:30. If I tell you I'm meeting you at the Dunkin' Donuts by court at 2:00 for the 2:30 hearing, get there at 1:30. Aim to get there at 1. You can't be too early. You're 15 minutes late, you're ordered removed. No ifs, ands, or buts. The traffic is terrible in the city, and the subways are not always reliable. So make sure you're there early. The night before, you want to get a good night's sleep. I know this one's hard and obvious, these last two ones actually, but I always tell that my clients when they're leaving their practice, make sure you get a good night's sleep the night before. And then when I ask them, how'd you sleep? They always laugh and say, terrible. But try. And also make sure to eat before, whether it's in the morning or in the afternoon. Make sure you've eaten, because you can end up sitting there for 3 hours doing testimony or more, and it could be pretty brutal if you're hungry. I know if I'm hungry, you don't want to be around me. So now that we're ready for our trial, what happens at trial? That's a great question. At trial, I'm going to walk you through now exactly what's going to happen that day of. Now, remember, I am talking specifically about asylum cases. However, the general outline here applies to all sorts of immigration cases. This is generally the flow of the trial, regardless of the type of relief from removal that you're seeking. So we get to the courtroom or the virtual courtroom. The judge, every single judge, the first thing they ask is has to have the two attorneys spoken. So me and the trial attorney or the government attorney. Usually the answer is no, because they're impossible to get a hold of. So the judge says, okay, would you like to? Yes, the judge steps out for like 5 minutes. That's when I get a really good chance to talk to the trial attorney about the case and find out where they stand. Are they going to narrow the issues at all? And I'll have, if you're my client, I'll have already explained all this to you, or reminded you of this if you're listening now. That basically, going in there, we're not going to know. We're going to most likely not practice your background information. You should know your name and birth date and stuff. We're probably going to start with the question of what are you applying for today, which is asylum. Um, but I'll also say, like, look, I'm going to talk to the trial attorney at the beginning. They might say, oh, the only issue we have is change country conditions. So I might not have to even go through your asylum claim with you. But what happens is I talk to the trial attorney. You'll be there. You'll hear. Take a pause. I'll tell you. Okay, here's what we agreed on. Here's where we're starting, and then the judge will come back and we'll get started. And then the judge will start with the admission of evidence. So there shouldn't be any new evidence submitted that day. Shouldn't be. Um, the judge should have everything already, and basically the judge goes through and says, okay, exhibit 1 is going to be this, your the um, notice to appear in immigration court. Exhibit 2 is going to be the I-589 application filed with the asylum office with attachments A through L. And they kind of go through all of them, and then they say, are there any objections? Generally, we have no objections unless the government has submitted some evidence, which is actually kind of rare in immigration cases. Government usually doesn't object too much. Hearsay is not really a thing in immigration court, which is helpful and not helpful, depending on how you look at it. But it does allow affidavits from people to come in, which is why I said they don't need to necessarily testify. So the trial attorneys will usually object to credibility or weight of evidence if you're late, timeliness. But for the most part, none of their, certain things you'll have to authenticate, which is a way to prove that evidence is real while you're testifying. But there's not too much of that formal evidence admission. Usually we take care of that at the beginning. Everything's admitted, done, move on. Then you get to the beginning of what is called the case in chief. Generally, no opening statements in immigration court. It is a bench trial, meaning you're doing the trial in front of a judge and no jury. I've done plenty of cases like that where I've done opening statements, but I think they're a lot rarer with just a bench trial. So usually we jump right into the direct examination. Now I have had on a few occasions where the government attorney said, look, I only have a few questions. Usually it's security questions. Like, have you ever been arrested? You can ask your client, or if you want, I could just hop in there and ask. And I generally let them, because I still get a chance after technically that's a cross and I'm doing a direct, but it's always a good sign when the government attorney only has a few questions. So you usually don't have anything to worry about. If it's a case where I know there's an issue, I probably will not do that. But again, that's the rare occasion. In general, this is the way it's going to go. There's going to be a direct examination. That's going to be, and you're going to testify first if you're the respondent in removal proceedings. And even if you have other witnesses, you go first. And this is your opportunity now to tell the court why they should grant you asylum. So it's similar to when you're at the asylum office, if you had an asylum office interview where they were asking you questions, the officer, and you were responding, telling your story. The difference is now I'm the one asking you the questions. I'm your attorney. I'm representing you, not the government. And I'm there to help you tell it. So the questions that I ask you, the way I shape them is to help you get your story out. One of the things with litigating is you have to be very flexible and move quick on your feet. And I don't literally move quick. I mean, you have to be ready for different things to pop up. I've never written down a set of questions and went through them one by one perfectly. You have to be able to, go with whatever your client throws at you. After the direct, the government attorney will cross-examine you. And that's when it gets that can be a little intense. That's where they ask you what's called leading questions, where they say, like, isn't it true that you weren't there the night of the 5th? Where it's a yes or no question. They're leading you to an answer. I'm going to get to our testifying tips shortly, which I recommend you holding out to listen to, but you want to listen to those questions very carefully, and you want to really be careful with how you answer them. But there's some good news. At the end of the cross-examination, I am given a chance to do a redirect. So everything may have gone great on direct, and then the cross comes along, and the trial attorney gets you confused, or you answer a few questions incorrectly. And as your attorney, I'm going to know your case just as well, if not better than you. So I'm going to know when there's a problem. Like if you say something that could be problematic, I can also tell by the way that the trial attorney responds. So I'm going to only do a redirect if there needs to be clarification. Now, after redirect, your testimony or that witness's testimony is supposed to be over. I just had a case on Friday where there were 3 cross-examinations and 2 or 3 redirects, plus the judge can ask questions, which is actually the next thing I was going to say, that at any time during your testimony, the judge can jump in and ask questions. Whether it's direct, cross, none of the above, the judge can jump in. But so yeah, sometimes you don't know exactly what to predict. But again, this is generally how it goes. If you have any other witnesses to testify at that time, will kind of determine if it's necessary. So there may be a little check-in with the government where the judge says, are you going to consent or defer to the court? Basically means that they're not taking a position, but which is their way of agreeing. If they're like, look, we don't need, they'll know what the witness is testifying for. They're like, look, we believe the person, we don't, the respondent, we don't need someone testifying, then they don't. But if they do, same thing. Direct examination, cross-examination, redirect. Also same thing. They should have practice with the lawyer beforehand, know what to expect, and make sure that the statement that they did submit initially is a very detailed statement and matches yours, because that is important, that they are not contradictory. After that, I've never had a case where the government introduced a witness. It's possible. So technically, the government can introduce witnesses now. But at the end of that, or if that doesn't happen, we then move to closing arguments. But first, what happens is, like I said before, the judge says to the government, what's your position? If they're not going to consent or defer to the court, we give closing arguments. I go first for my client, and then the government goes. There's no like rebuttal, nothing like that. It's not timed. Practice manual might have a time limit, but I've never gone over. You kind of just spell out for the judge, here's how my client's eligible, and this is why you should grant it. And then sometimes the judge will say again to the government attorney, do you agree? You consent? Will you defer to the court? If no, then one of two things will happen. Either the judge will issue a decision right then and there, which is what we always want. Well, only if it's good, of course, but in general, we want to know what's going to happen. Or the case will be adjourned to a future date for decision. So the judge may say you have to come back in 3 months, or the judge may say I'll mail out the decision when it's ready. Don't think about it too much. Why is one person being asked to come in for a decision, whereas another person is getting it mailed? A lot of times it just has to do with the judge, doesn't have to do with whether your case is going to be granted or not. And so that is really the whole walkthrough through immigration court. So let's get the exciting portion here, our tips for testifying. Now, these are my own personal tips that I have compiled over the years that I give every single client before they testify. I can guarantee you one thing: if you follow these testifying tips, your testimony will be better than if you don't follow the testifying tips. That's all I can promise. Um, okay, so the first one: only answer the question that is asked. Very important and most important. Listen to what is being asked. Now, if your attorney practiced with you, you should know the questions that are going to be asked. But even then, like I said, I'm going to have to go off script sometimes because you're not going to give me exact every answer back how we wrote it down if we wrote it down. And that's okay. It's more important when the government attorney or the judge is asking you a question that you listen, because they're trying to see if you're lying. I'm not trying to see if you're lying. I don't believe you're lying. You're my client. If I thought you were lying, I would not be allowed to continue to represent you. So I'm trying to help you just tell your story and look good. So my questions are not gotcha questions, but the government attorney and possibly the judge will. So really listen to what they're asking you. Only answer what they're asking you and nothing more. So the worst example I have, which is the example I use every time, is I say, do you have a name? Here's our example. Do you have a name? And the client will always say 90% of the time, yes, and then tell me their name. I cut them off. I say, no. I ask you, do you have a name? It's a yes or no question. The answer is yes. If I want to know your name, I'll say, what is your name? That will be my next question. So really listen. What are they asking for? Did they ask what your name is or if you had a name? Again, that's a horrible question because everybody has a name. So it's a horrible example, but gets the point across. Listen. Listen very carefully. The second thing, if you need an interpreter, use one. Do not be ashamed. And if you do, when you do your practice, practice with the interpreter and do not speak in English at all. So this is one thing that really gets under the skin of the immigration judges. If you say you need an interpreter, you're not speaking English. So when we do our practice, we want the same thing. I ask the question in English, the translator translates it to your language, you answer in your language, they translate it back to English out loud. And that's it. Even if you understand the question in English, don't answer it at all until it's translated. And also, when you're answering questions for a translator, you don't want to speak for 5 minutes straight. You want to, maybe do 2 to 3 at most sentences at a time, because they have to listen and hear everything that you say and do a proper translation. So you're going to get a better translation if you go slow and you take pauses. If you don't understand the question, do not answer the question. Say, I do not understand, and you will be asked again in a different way. If you're asked again in a different way and you still don't understand, say, I still don't understand. That's happened to me plenty of times, usually not to my question, but to the government attorney. And again, I still say it's more important when they ask you, because you don't want to be tricked. So don't try to answer something if you're like, I don't know what they're asking me. In a similar manner, if you don't know the answer to a question, just say you don't know. Do not try to make it up. Remember, the biggest thing they're trying to do or determine is, are you telling the truth? And when you sit there and you try to make up an answer, they're trained to be able to tell that. So, as I said earlier, ideally you remember every detail of your case on your application and your statement, everything. But not everybody has that type of memory. It's okay to forget certain things, and it's okay to admit you forgot certain things. It is better to say I don't know or I don't remember, or to give an estimate like, I know it was like this long ago. I'm not sure, but it was around, October 2023, whatever it is. Get as close as you can, but it's okay to make it clear that you don't know exactly. If you have any emotions, any natural emotions, like you start to tear up, I normally don't see too many happy emotions unless their case is granted, um, go with it. Go with it. I mean, you want to be natural. It's okay to cry. I say that again. It's okay to cry. Don't force yourself to cry and be fake, but a lot of clients don't think they're going to cry. They start the testimony. And again, you're reliving some really horrific um, circumstances or events in your life that has happened, and sometimes not even that long ago, or you may not have dealt with the fallout from it. So if you do have emotions, go with your emotions. Just be honest about it. And my last tip is it's okay to be nervous. You're going to probably be nervous. Most people are. What I also tell every single client, and I truly mean this, is if you're telling the truth, you have nothing to worry about. You just have to answer the questions. Like I said, it's okay if you forget something. You don't have to worry about understanding because you do not answer until you understand. But it's okay to be nervous. And sometimes accepting that and understanding, like, look, I'm going to be a little nervous, helps people be less nervous. So those are my main tips that I give all my clients. Now, before I get going, um, the only part I didn't mention is what happens if you lose. And that's for another time, but your case isn't necessarily over if you lose. Um, you may have a good appeal. I see on Instagram somebody's asking 17-year-old and I'm a citizen of Uzbekistan, can you help me? Um, well, I'm not sure what you need help with or where you are, but contact me, send me a direct message. This is 7Dior on Instagram. If I can, I will. But I don't know anything, and I don't want you to write it publicly. Please, just send me a direct message, and I'll be in touch with you. So if you have an individual hearing coming up, or even a master hearing, and you need an attorney, as I said at the beginning of this video, please reach out as early as possible so you can get all your ducks in a row. And it's so much less stressful when you have everything done, because a lot of times people wait and they don't realize what evidence they need. Like I said, you might be getting it from abroad, but really these cases are just so much more tolerable when you're prepared and you're not stressed for months or years, and we can certainly help you with that. So if you or someone needs help with their immigration proceedings or asylum case, on Facebook and YouTube, our contact info scrolling across the bottom of your screen. I don't know if they saw that. And on Instagram, if you go to our bio page, you can find our contact information there. If you found this video helpful or know someone who may, please hit that like or follow button. Leave a comment. And if you know someone who might find this video, I just said that. If you know someone who may find this video helpful, click that share button or save button. There's all these buttons to click. Somehow, keep us in mind so that you do not miss any more of our videos. I'll be releasing more videos on tips, on winning your case, and of course, my notable approval series. I'll be talking about some more recent wins in the near future. It's been pretty busy around here, which is always a good thing. And that is all for today. Thank you for watching and have a good day.